All rise. The Court of Appeals Division 1 is now in session.
Please be seated. This is the time scheduled for oral argument in our case number 1, CV140567, Owner-Operator Independent Drivers Association and others versus Pacific Financial Association and Federal Service Corp. Each side has been allocated 20 minutes for oral argument. If the appellants desire to reserve any time for rebuttal, you may do so. There's a clock in the podium. It'll show you how much time you have left of the 20 minutes, including your rebuttal time. So you have to manage your own time. If it shows 5 minutes left, that includes any rebuttal time you have. To assist you in your arguments, you should be aware that we've read the briefs, we've looked at pertinent portions of the record and pertinent cases, so we're familiar with the arguments and the facts involved. While each of you have been allocated 20 minutes, if you're done arguing and we don't have any further questions, feel free to sit down. Finally, please be aware that we are recording, orally and visually recording the argument. So as you approach the podium, when you approach the podium, please first state your name and who you're representing. And in a couple of weeks, you probably could see the video on YouTube. Is that right?
I believe so.
I think it is YouTube. So with that, counsel for the appellant.
Morning. I'm Daniel Cohen of the Cullen Law Firm, Washington, D.C., appearing on behalf of the plaintiff's appellants. With me is Mr. Brian Campbell of the Campbell Law Group, Phoenix, Arizona. I'd like to reserve 5 minutes or the balance of any time I have left. May it please the Court. This is a case of first impression in this court and a case of critical national importance regarding whether the trustee of a federally mandated trust is immune from liability for the torts of negligence and fiduciary duty under Arizona statute and Arizona common law. The trial court ruled that the trustee is immune under Arizona statute because of ARS 14-1201. And in ruling that the trustee is immune from liability, the trial court focused on 8 words in 1201. The statute.
Counsel?
Yes.
When you say immune from liability, I take it to mean what you're saying is that it's not, to the extent this is a trust, it is not a trust subject to the trust code. Is that?
It has been Pacific Financial's position that it's not actionable under the trust code because it's excluded, right, but also that it's not actionable under common law.
Right.
Yes.
But let's assume that we thought it was actionable under common law, or at least the common law wasn't abrogated as far as trusts that aren't included in the trust code. One thing I just had a question: what difference does it make? I mean, if is your remedy broader under the trust code, or could you still get all the damages you would be able to get under the trust code through if you could prove your case under a common law breach of fiduciary duty claim?
I understand your question. I don't believe it makes any difference. We did not differentiate between whether our claims were actionable under the code or under common law in our complaint. When the judge ruled that it was excluded from the code, we naturally moved to amend to ensure that the trial court was aware that we had always sought relief under the common law, and we wanted to have a complaint that made that clear, and the judge denied our motion to amend. But I think the remedies would be, well, coextensive. There are some statutory, declarations we could have gotten, but I think the ultimate relief we were seeking would have been available, yes, sir, under common law.
I want to make sure I understand precisely the nature of the common law claims that you wish to pursue through the amended complaint. As I read the proposed amended complaint, your clients were attempting to assert just plain old common law claims for negligence or breach of fiduciary duties under Arizona common law. Am I correct in reading it that way?
Yes, but not to be divorced from the fact that the trust is a federally mandated trust.
Well, that I understand.
Yes.
And the reason why I'm raising this is because I want to make sure I really do understand this. We have our Arizona Trust Code. Okay, that's statutory.
Yes.
We then have the common law. And then I think where I was confused is, are you making the argument that there's some additional trust common law that's still out there that's not been superseded by the code? Or are you just wanting to pursue plain old garden variety negligence, breach of fiduciary duty claims that, of course, arise in this context within the ambit of the federal statute?
Well, I think I understand what you're saying. Yes, we're seeking relief under the regular old common law.
Okay.
But it's important for us to point out that, contrary to Pacific Financial's argument, the common law is not displaced or abrogated by the statute. So we're saying if we're not entitled to pursue the statutory remedies or seek relief under the statute, we are separately entitled to pursue the regular old common law claims of negligence and fiduciary duty.
And getting then back to Judge Kessler's point, insofar as you know, the remedies that would be available to your clients, either if in fact they had a claim under the Arizona Trust Code or the common law, they're basically the same?
I would think so.
Okay.
I mean, the prayer for relief we asked for, I think, is available both under the code and the common law. I'd like to go back to
Hold on, counsel. I just have to be clear on this, too.
Yes.
So generally what you're arguing is the federal statute creates a special relationship that imposes certain duties, and those duties are fiduciary duties, all sorts of duties, if you were to allege your claim under the common law. So it doesn't really turn on a trust per se. It's the special relationship that creates various duties. Is that accurate? Okay.
Yes. Right. That's what creates the express trust. The statutory or the federal mandate creates the special relationship and in turn creates the statutory trust. Going back to the fundamental error that the trial court committed is the trial court focused on 8 words in ARS 141201. Those words were trusts for the primary purpose of paying debts. Those 8 words are taken out of the context of the full passage in that statute. The full passage reads, trust excludes trust for the primary purpose of paying debts, comma, dividends, comma, interest, comma, salaries, comma, wages, comma, profits, comma, pensions, or employee benefits of any kind. When you read the passage in its context, you can see clearly it does not relate solely to any trust for the primary purpose of paying debts. As we pointed out repeatedly, if that were the reading of this statute, you would exclude from the trust code every trust that had a purpose of paying debts. The judge ruled that he could not read that language without rendering, or he could not read the express trust language without rendering those 8 words superfluous. In actuality, that's exactly what the judge did. He rendered that entire passage superfluous because it relates solely to employee benefits of any kind.
What do you do with, counsel, what do you do with the word primary then? It says primary purpose of paying debts. How do you construe the inclusion of that specific term and defining that type of trust?
Again, I believe you have to go to the subject of the whole passage, which is employee benefits of any kind. It's not primary purpose of paying debts just in the abstract. It's primary purpose of paying debts, dividends, interest, salaries, wages, profits, and then the subject is employee benefits of any kind. Now, if you deconstruct it again, you could take the word interest and say, well, this statute is for the primary purpose of paying debts, dividends, and interest. Well, we know that many trusts provide for the payment of interest. You certainly could not conclude reasonably, I don't think, that this statute excludes all trusts that have a purpose of paying interest. Many trusts have that purpose. So we submit that the judge did render the remainder of the language superfluous by just focusing on those 8 words.
So your point is that it can only be if it's the primary purpose of paying debts in the form of employee benefits.
Precisely.
Your argument is that the end words, employee benefits of any kind, basically modifies all that came before? So you're really making a last antecedent rule argument?
It's not everything in front of it, because there's a beginning phrase, liquidation trusts, and here's where the antecedent language begins. And trusts for the primary purpose of paying debts, dividends, interest, salaries, wages, profits, pensions, or employee benefits of any kind, comma, and then it begins with another type of trust. Trust created by a city or town, and so on.
As I read that language, it appeared to me that the definition was attempting to carve out, for lack of a better term, commercial or business or maybe a way to put it, it was attempting to carve out non-gratuitous transfer trusts.
Well, you can see, I guess, based on your wisdom, what it might tell you.
I'm not sure I have it.
But I think that if you look at it as it's written, it would you could splice it and extract it in a number of different ways. But if you read it in its context, it ends up with employee benefits of any kind.
Let me ask you about this then. Let's say we agree with you, or maybe we don't even have to reach that issue. The exclusionary language also excludes trusts that are security arrangements. And clearly the statute and its commentary impose this system as security for carriers. I mean, the characterization of this throughout the history is that this was a form of security arrangement, much like a suretyship or a surety arrangement. So why doesn't that exclude it just by itself?
Well, that was not an argument that Pacific Financial put before the trial court.
They may not have raised it, but I'm raising it now, okay?
It just shows a lack of confidence, perhaps, in their original argument. But the same response applies. They cited no case law that supports that definition. As far as we could see, there isn't any case law that defines a security arrangement. As far as I could tell, it related to real estate transactions. And again, this is a federally mandated.
But what's the purpose of the federal statute?
The purpose of the federal statute
is to provide security. You make that point in the briefing. So isn't that a security arrangement? It
provides protection for carriers against unstable and dishonest middlemen. Pacific Financial and entities like Pacific Financial are supposed to monitor the conduct of the people that they sell these trusts to. They are supposed to carry out a number of trust duties in making sure that they don't violate the federal regulations. The fact that the word security is out there results in the same attempt to force into the statute some word that you can find in the fabric of the regulation. It provides security. Is that a security arrangement? I see no authority for this statute, the phrase security arrangement in this statute covering this federally mandated trust.
They've not cited any cases. Do you have any cases that talk about what a security arrangement is? how's been defined?
No.
None.
We haven't seen any. No one's ever used this argument before, that this trust is somehow excluded from the model probate code under that characterization. But regardless, going back to our arguments on the trial judge's exclusion of the trust under paragraph 58, the same argument would apply to security arrangements. We have a separate provision in the Arizona Trust Code which protects statutory trusts. And under the peri materia doctrine, we submit that they could both be upheld side by side without rendering the other one invalid.
But why isn't it, why can't we view this as 10102, I think that's the right statute, right, that talks about statutory trust created by statute as being within the trust code. That's the universe, okay? There's a universe of trust created by statute that would be subject to the trust code, except that subset of 120158 where they're expressly excluded from the trust code. Why couldn't you view it that way and still harmonize both statutes? Because in one would be saying, yes, if it's so in essence you'd be saying, if it's a trust created by statute, it's under the trust code unless it's one primarily for paying debts. Putting aside your last antecedent argument.
Well, that wouldn't be harmonizing, I don't believe. That would be excluding the statutory trust, period.
I was just saying a trust that was primarily made for paying debts, even if it was created by statute, wouldn't apply, wouldn't be under the trust code.
Well, we believe the peri materia doctrine should require both to be respected and both to be harmonized, and we submit that this federally mandated statutory trust should be given respect independently in the Arizona Trust Code, which it is more specific in it, and I believe it did come later than this uniform probate code. As we've discussed briefly, even if the court doesn't believe that this is protected by statute, it is protected under Arizona common law. The common law was not abrogated. It was not modified. It's still to be respected. Otherwise, if you accepted the argument that every security arrangement or trust for the payment of a debt is excluded under the code, well, any trust for the payment of a debt, security arrangement, or payment of interest, according to Pacific Financial, would not be actionable under common law. We submit that's fundamentally wrong.
Right. Well, although I think they argue that they could be sued for breach of contract by a third-party beneficiary.
Well, they implied there's some other way at it, but we don't see any other way. It's called a trust. It's a federally mandated trust, and it's a dog. It's not a horse, and we have to live with that. I'll reserve the rest of my time. Thank you.
Thank you.
Good morning. Lonnie Williams on behalf of defendants appellees. Let me start, if I could, with your first questions that you asked to my esteemed colleague, because I think there's some misunderstanding. Their proposed amended complaint did not seek a claim under simple common law for negligence. That amended complaint sought damages as a common law trust only. And this case is all about their need to come up with an argument that a trust is created. You also asked a question that's telling, which is, would your damages be the same? And the answer to that, and I don't think it's disputed, is no, because the federal courts have dealt with this issue under these regulations in this context, not in terms of the trust fund, but in terms of the surety. Remember, you have two choices. You can do a surety type arrangement, or you can have a trust fund. And in the case both of us cite to you, which is RLI Insurance versus All-Star, the courts dealt with this issue. In other words, their damages under a straight common law negligent claim or a contract of a third-party beneficiary is going to be limited to $10,000.
Forgive me, I don't remember, when a broker elects to use a surety bond arrangement, and of course it's a different form, Form 84, does the surety have the same obligations to notify the federal agency that the broker has started to default on claims?
Yes, if it
So-
goes under $10,000 and they have a period of time.
So the same reporting mechanisms are in place?
And keep in mind, the same mechanism got to the two forms. The statute, the regulations, and we both cite to some of the commentary. But the answer to your question, when you look at the amended complaint, the proposed, they were seeking simply to go from a statutory trust to a common law trust, because without that, they wouldn't have filed this lawsuit. Because RLI Insurance is very clear, under this statutory arrangement, unless you are outside in some trust fiduciary duty, they can go after the $10,000, and that's it. And that's not what they were seeking to do. And if you have any questions, all you have to do is go to their prayer in their amended complaint. Going back, I think the trial court clearly read their proposed amended complaint that way, because the trial court, in essence, in adopting our argument, is that the trial court ruled two things, really. That this isn't a trust under Arizona law, regardless of whether it's statutory or under Arizona common law, because the agreement and the regulation and statute that gets you to where we are does not create a trust arrangement. And that's really the key to the court's ruling. It doesn't matter which way you go. And if you look at the case law that have been supplied by both parties, it's hard to reach a different conclusion. Counsel, in their reply brief, discounts the fact that, one, Arizona law applies, and Arizona has already ruled on what this court should do in determining whether or not a statute or regulation creates a statutory trust. And that is in Arizona Farm Bureau Federation, decided in 2010, I believe. I may be wrong on the date. And that dealt with farmers and money going in and the state needing to take money during the fiscal crisis. And the court specifically was dealing with a statute that used the term trustee, just like the 85. It uses the term trustee, but the court found that all the other elements that you look for in a trust were simply not present. And I think that's also true of a case we both cite, which my esteemed colleague's firm handled, and that's in Ray Arctic. In that case, the court goes through a detailed list of obligations that led the court to conclude that a statutory trust was sought to be implied. Here, we don't have that. We have a security arrangement. We have a situation that the very document issue says that my clients can treat the money as theirs. They do have a fiduciary obligation as it relates to how they treat the money. The agreement is very clear that there is, or is silent on any idea that there is a fiduciary obligation to some people who might someday have an interest in those funds. And I think that's key, because the day one in the situation in Arctic, they had interest in those funds from day one because they paid them. They were paid into the account for the purpose of paying repairs and maintenance. It was their money, and this entity was there to protect that money and pay it out. Here, no one has an interest in this money until there is a default by the broker and a claim made and a determination made by my client that the Broker is legally obligated to pay.
I want to make sure I understand your argument. I recognize that under the agreement, the broker pays and turns over the $10,000 to Pacific. I heard you say, or I thought I heard you say that it becomes Pacific's money, and that is, I think, technically true as a trustee. But it's not Pacific's money in the sense that it can do anything it wants with it.
No,
No,
Judge,
I mean, it has to, I think, segregate it. It can't just put it in its general fund, can it?
Judge, it can use the money for the purpose of investment because that's
I
how...
understand. It can't just let it sit there after all.
No, I
Yeah.
agree, but
Yeah.
the difference is it has legal title to the security and trust fund.
Mm-hmm.
I'm distinguishing that from a situation in INRI Arctic.
Mm-hmm.
In the analysis the court went through, I'm not suggesting that there's not a fiduciary obligation in how you treat the money, because the agreement says that. But as it relates to whether or not there is a clear intent to create a statutory trust, you need more. In those two cases, the Arizona case and the INRI Arctic case, give us that test, because they're basically saying the same thing. Arizona is saying the same thing that the federal appellate court said, and we don't have that. What they've done is they go back to the statute and the regulations and say the primary purpose is to protect the shippers, and we agree with that. But that's not enough to indicate that Congress or the regulators intended to create a trust. And if there's any question about that, I suggest that the citation that we both talk about, which is the property ICC Commission, when they actually approved the Form 85, gives you that answer. Because in that discussion, that property broker's security for the protection, they, in detail, indicate why they're doing what they're doing. And this is on page 146 of plaintiff's brief, the page or paragraph 4 of the actual citation from the ICC, and they talk about, they agree with the comments that any security instrument, now I think we all know that a security instrument is different than a trust. And they go on to talk about any security except it, and it lists the things that it has to have, and it lists 3 things. And when you look at those 3 things, you do not come out with saying that the regulators intended for there to be a trust. They use trust fund many times, and I suggest that if they intended to give us an indication that this was going to be a trust, the terms they would use would be clear: in trust, a trust, and they didn't do that. All of that leads us to the conclusion that unless you can read their proposed amended complaint to seek a simple negligent case or breach of contract based on
How about breach of fiduciary duty?
breach of fiduciary duty would imply a special relationship, and I believe that the court basically dealt with that. There is no indication that this agreement, and it is a matter of law, created a fiduciary duty or a special relationship. That argument or that claim or that allegation was part of the original complaint. Again, the agreement talks about fiduciary duty in the terms of dealing with the $10,000, because keep in mind, when that money's paid, none of the plaintiffs or anyone like them is in the picture. So who is that fiduciary duty owed to? This large group of potential people? And that's what I believe the trial court ruled. So they do have a claim they chose, for the reasons set forth in RLI, insurance company, not depleted.
Let me ask you a question, counsel. Do you see any distinction in the development of trusts in the probate code and in the Uniform Trust Code vis-a-vis commercial trusts and decedents trusts? What I'm getting at is, the definition of a statutory trust is under the Uniform Trust Code, and then this more restrictive definition that we have regarding solely to paid debts, that's in the Uniform Probate Code. Now, the Probate Code is dealing with decedents' trusts, those types of things. We know that commercial codes are everywhere. They're ubiquitous and are really kind of different animals. And I'm wondering if in interpreting these two statutes, 14-10102 that talks about statutory trusts, and then the definition of a trust under the probate code, under 14-1201-58, we're really talking about two different kinds of trusts. Maybe they're mutually exclusive. Have you thought about that?
I have, and for the purpose of this case, I don't think it makes a difference. But to answer your question specifically, I don't think, given the definitions and the common use of the terms, that this court should interpret two terms like express trust, which is used in both statutes, differently. I think when you have express trust, statutorily created trust, and then you come over and you have a definition of trust which encompasses some of the same, that you have to interpret the language consistently unless the legislature has indicated some different application. I agree with you that there is some, it's strange that could you have a statutorily created trust that would somehow be excluded by 58? And I don't think you ever could.
Is it possible to interpret the definition in the probate code as saying the probate code doesn't deal with commercial trusts? We're not including that kind of trust under the probate code. We're dealing with the inter vivos trust, the decedent's trust here, so we're excluding those. And then you go over to the Uniform Trust Code, and that just describes statutory trusts. There are two different kinds of trusts, and that the probate code effectively says we're not dealing with those. Go to the trust code to deal with those. That could be one way to harmonize them.
It would be, Judge, but I believe the legislature, in all due respect, and not the courts, would have to do that because of their use of the same words and because they're talking about trust. I think that would create a distinction that we do not get in the statute, and I don't see the inconsistency. I think the exclusions are simply making it clear that there are certain items that you might consider trusts that clearly don't meet that purpose. But until we have a situation, which we don't have here, of a statutorily created trust that somehow would fit the other items in 58, it's really not an issue that needs to be decided here, in my opinion.
It almost seems like, when you look at all the things that are excluded under this definition of a trust under 14-1201-58, it excludes all those commercial trusts, the ERISA trusts, all the bundling of loans and things, under MERS and all those kind of commercial real estate trusts. None of those would qualify as trusts under this definition under the Uniform Probate Code, but they are trusts.
Well, they're not trust under the Act. And again, I think the legislature, for whatever reason, made that decision. And I don't disagree with you that when you get past the one at issue here, which is for the primary purpose of paying debts, you do get in those murky areas. But when we limit it to what we're talking about, the idea that the payment of a debt, primarily being the key, is a trust, is consistent. It is not a trust, is consistent with common law. And I'm trying to avoid the murky area that the other areas get into.
Is that really a fair characterization of what they're trying to do with this statute? Though it's to pay the money out, but it's also to make sure that brokers don't do bad things. I mean, the purpose of it, it's really more than just that. It's not just a money relationship, is it?
I would respectfully disagree. And again, when you look back to what the ICC talked about in listing the items, they talk about the need for a third party. to make sure that money is available and when payment needs to be made. And they also talk about the third party must agree to give notice. So someone tells the government when there's a problem. And I also acknowledge that they also talk about the commercial reality, that no one's going to take on this deal unless they think the person's financially responsible. But that's a byproduct of the whole arrangement. There is nothing that anyone can cite to other than the general statement that we want to protect shippers that would impose the type of fiduciary obligations that they allege to be on my client, which is not just to pay the money when the claim is due, but more so to make sure there's not too many claims coming in or a timely processing under some other standard. Those are obligations that they can't get from the BM85 in terms of that. And I don't think those are part of this, because if they were, the federal statute or the regulators would oppose that. And keep in mind, if we accept their argument, which we still contend they waive, accept it, that there is a federally mandated trust, we don't need the code if you look at the other cases, because in all those other cases, the regulators imposed all of the obligations. Look at In Re Arctic. You don't need a trust code because the regulations said you got to do this with the money, you got to account the money, you got to do all of those things. And so the trust was imposed based on the requirements of the regulators. Here, the reason we're here is because we don't have any of that. So they want to use the trust code and impose all of those obligations where no one has set forth those obligations or impose them on my client, and they don't want to do it under a straight negligence theory, which is pretty easy, simply because they'd be
As
limited.
opposed to the type of requirements that would be imposed on a ERISA pension trust, that type of thing.
That is in the statute, and we all know it's in the regulations. Clearly, those are statutorily imposed trusts, and they come with obligations. And you also don't, and one final point on that. We all agree this agreement is governed by Arizona law. They are, in essence, saying to you that the federal government set forth a situation of imposing a federally mandated statutory trust that would be interpreted 50 different ways based on what every single state was going to do based on their own state law. That's not the case in ERISA. That's not.
Oh, forgive me. I think the federal district court in this case in its remand order made that precise point, that these arrangements are to, in fact, be governed by state law, and there may well be variations in state law. So,
my point, Your Honor, is that what they're arguing would be that you would have, you're having interstate commerce across this country, and what would happen if you did have a federally mandated trust would differ depending on what state someone put down on an agreement.
I understand the point. I'm just saying that the case law that deals with this federal statute specifically discusses that state law applies and there can be variation in the law applicable in these arrangements.
And I agree with you,
Okay.
and I think that also indicates the lack of federal mandated trust by the fact that they are leaving it up to state law to deal with any individual liability, because state law and common law are capable of doing that, and limiting whatever damages might flow from that, as opposed to what they are trying to do. And I believe my time is up. Thank you.
Thank you. Judge Norris asked the question whether our remedies would be coextensive under the code or under common law. Pacific Financials argued that some remedy would be available under federal law, which is not the case here. We're not seeking a remedy under federal law. We're seeking it under Arizona state law. The argument about the RLI case involves a BMC 84 surety. It's not a trust. It doesn't impose any fiduciary duties. And that's what distinguishes the surety from the trust. The trust manifests the ICC's intention that there exists a fiduciary duty. Judge Norris asked those questions. There is a fiduciary duty. There is a special relationship that's created. And there is the intention to provide the remedies available under state law for a trust. The argument was that the trial court somehow found it wasn't an express trust. That's wrong. I think the trial court accepted that it was an express trust, but found that it was excluded under 1201-58. And that's why he said, yeah, even if I were to recognize it as an express trust, that would render superfluous the primary purpose of paying debts language. There's certainly no express finding that he rejected it as an express trust. The Arizona Farm Bureau case had one word in it, trustee, and the court found that's not enough to create a trust. Here we have a federally mandated trust that has all of the bells and whistles of a trust.
Well, under Arizona law, a trust has to have a competent settlor and a trustee, a clear and unequivocal intent to create a trust, an ascertainable trust race, and sufficiently identifiable beneficiaries. So what your argument is, well, you've got a settlor or a trustor and a trustee. Maybe there's a clear intent to create a trust. I mean, at least you've pled there was one. Under the common law, there's a trust race, which is the $10,000, although the duties may or may not extend beyond that, and then sufficiently identifiable beneficiaries. So those are the 4 requirements, right?
Yes, and we meet them all. If there's any question
For
about
purposes of pleading, you've made those.
Yes, and if there's any gap, conceivable gap, you can find it in the ICC decision that Pacific Financial cited. There you have all of the objectives of the agency spelled out, and that's what determines that this is a trust protected under the Arizona Trust Code. It's enacted pursuant to a statute. The Arctic case answers all the remaining questions. It provides that a regulation doesn't need to use the word escrow or trust to be protected as a statutory trust.
And that dealt with an escrow with a bank. I mean, it's not directly bearing on this kind of case.
Of course, not on its facts, but on the law, it's even a better case for Pacific Financial to say, well, there wasn't any mention of an escrow or a trust. There wasn't any, but the Sixth Circuit said this is a statutory trust. And by the way, the court held it was bound by federal common law. We submit that the district court's or trial court's decision should be reversed. It's unprecedented, erroneous, and dangerous as a matter of Arizona policy, but nationwide as well. Thank you.
Thank you. Thank both counsel for their arguments. We will take this matter under advisement and issue a written decision in due course. We will take a brief recess while the parties to the next case approach the bench.